Welcome everyone to this, our second annual summer winter school on human rights and the environment. I'm welcoming you today on behalf of the United Nations Environment Programme and on behalf of the Global Network for Human Rights and the Environment, who are the partners who've been organising the school for the last 2 years. We've also had incredible support in bringing together this program from the One Ocean Hub, because our theme this year, as you know, is water from oceans to taps. We're looking at all aspects of water and the environment and human rights. And we are also supported this year by the University of Southampton. Thank you all for being here, and a special thanks to our panelists. I think we're going to have a really fascinating discussion today on conflicts in use of transboundary waters. It's really a critical issue at this point. And a special thank you to my colleague Clive Vinty, who's put this panel together and who is going to do the hard work of moderating it. So without maybe one further ado, please use the chat box as much as you like during the session. Ask us questions, make comments, raise concerns, but we will also have an opportunity for a conversation after everyone has given their presentations. You should all be able to use reaction buttons at the bottom, so you can raise a hand, but let us know if you have any problems with using any of the facilities related to Zoom. Clive, over to you.
Thank you, Dina. Thank you, everybody. So welcome to our summer school under the Global Network on Human Rights and the Environment. My name is Clive Vinty. I'm based in South Africa, more specifically in the University of the Free State. I teach environmental law. I work together on putting on this panel. I work together with my other directors in the African cohort, with Angela Kariuki, who's also with us here, and also Caiaphas Soyapi. Caiaphas is unfortunately not able to join us, but he's obviously sent his regards. So I still have at least Angela here, together obviously with Dina. So Dina and Angela are the ones that actually put this summer school together. I don't know how they did it, but they did it. I'm so grateful to them. I'm just doing actually the easy work, Dina, because I'm just simply sitting in and listening to what I call an all-star cast that we have here. So welcome everybody. The panelists that we have today for this event, just gonna give you a brief introduction, but I think it would be much better if I give each person's bio as and when they speak. But we've got 3 panelists. We've got Mr. Bokkang Makkota, who's with the Lesotho government under the Lesotho Highland Water Project Agreement, who will speak a little bit more. I will introduce him when he comes in. We also have Mr. Robert Wabunoha, who's also with the UNEP regional office. He works in water governance. Then we also have Professor Owen Mcintyre, who is a professor at the School of Law at the University College Cork. So we've got 3 luminaries in the area, and we tried, as we're compiling this panel, to have people from an intersection of different skills. So people from the academic field, people from government, an example of a government that is involved in a transboundary project, and also try to have at least someone from UNEP. So we're very grateful to our 3 different speakers who come from, I think, vastly different backgrounds, but obviously I'm sure their work has intersected, as they've also obviously all met each other. But by way of introduction, so what is this class about? It's about conflict of uses in transboundary waters. And we have 90 minutes. So the structure is such that we're going to have the 3 speakers speaking for about 15 to 20 minutes, teaching us on that. And then the last 30 minutes, we're going to have a Q&A session. So feel free to pop your questions in the Q&A. We'll try and record them. The speakers will also be checking on the questions, and they'll obviously respond to you, hopefully in the last 30 to 40 minutes of the session. Now, by way of introduction again, the idea of conflict of uses, in my mind, anyway, emanates from when I was doing my own research on transboundary waters. The idea of conflict of uses speaks to the idea whereby the quantity and quality of water in what is called either an international or shared or transboundary watercourse is insufficient to satisfy the needs of all the riparian states. So you have 2 countries or 3 or 4 countries that share a specific water resource, and the question becomes, what happens if there's not enough water? So it could be an issue of climate change or mismanagement of the water, whatever factor that might cause that shortage in the water. There might be a factor that leads to a dissipation in the quantity of water or just a reduction in the quality of water. So if the quality of water reduces, inevitably, it means there's less quantity in terms of water. And how do you resolve that particular type of issue? And this is bearing in mind that we know that that the majority of water basins that we have are shared between different countries. So a lot of countries share water resources. And the question that always arises in that context is to what will happen if there's insufficient water there? Whose rights take primacy? Is it the upper riparian state, or is it the lower riparian state, or the nations that are in between those two states? Who actually has primacy in terms of water, or are they supposed to share this water, or what can happen? And we always hear about that whole oft-repeated statement about the idea that water can either lead to conflict or it can lead to cooperation. So the three panelists we have today are going to speak about their experiences and their knowledge in the area as to how does one go about dealing with a conflict of uses within a transboundary or shared or an international watercourse, and their experiences related to that. Of course, this touches on issues relating to the human right to water. In some countries, you speak about the right of access to water, not really the right to the right to water. And obviously also the attendant issues related to the vulnerable groups, for example, like children and women, as well as the indigenous communities that are proximate to these water basins. How do you resolve all those rights and try and resolve it? But anyway, without much further ado, you're not here to listen to me. I was just simply giving you an introduction. People are here to actually listen to the actual experts in the area. So by way of order, we'll start with Mr. Robert. Mr. Robert, we'll start off with our session with him. Secondly, after that, we'll have Mr. Makkota, which is Bokkang, and we'll finish up with Prof. Owen. So Robert Wabunoha is with the UNEP Regional Office for Africa. Robert is the Regional Coordinator for Environmental Law and Governance and has extensive experience in the area of water governance and implementing transboundary water arrangements. Robert has agreed to speak during the panel session for us today, and he might not be able to be there towards the end of the session because he's got other commitments, but we're able to at least to coax him and convince him to join us for today. So Robert, please take it away. Feel free to, if you want to do an outline like you're doing, or if you want to speak just straight up, it's fine. So Robert, please take over. I'm handing over the reins to you now.
Thank you, Olive, and good afternoon, good morning, good evening, all the participants, and also the panelists with me, Makkota and Professor Owen. Of course, all of us owe our learning in water from Professor Owen because of his long-standing legacy in this subject matter. I learned a lot from him. He may not know, but I did a lot from you. I think we worked together a number of times. So my point, I will talk about transboundary agreements in terms of conflict management. And being a historian, I will go a little bit deeper into the past to the present and outline and give a foundation of the state of international waters, a few areas for the development of the principles, the complexities involved, the main trends in the 20th and 21st century, and then end with some solutions. To state on the state of the environment, the shared water resources as they cross frontiers, link users, they also cause conflicts, but also cause cooperation among the different users and users. With over 45% of the earth accounting for the global fresh water and 40% of the world population living in transboundary water basins, with 263 international draining basins which cut across 145 states. That is in terms of the surface water. But when we go to underground water, we find the underground waters supports a lot of land ecosystems. There are over 400 transboundary aquifers worldwide. And groundwater is the most extracted natural resource we have, supplying more than a half of humanity's fresh water and 20% of the total irrigated agriculture, with 20 billion people depending on ground supplies. There's little attention paid on its governance systems, and it's also affected by over-exploitation and pollution, and therefore being a potential for conflicts in the world. Going back, as I had mentioned to you about how some of these international principles on freshwater came about, freshwater is among the earliest centers of civilization, where many human beings used to congregate. We have the first treaty which came in 2500 BC. That is between the state of Lancashire and Umma. We also see that civilization, irrigation, when irrigation started, was around freshwater resources. Canals and dikes forced communities either to cooperate or conflict among themselves. And the breakdown of cooperative relations, which used to lead to conflicts and formation of empires, is formed around those resources, freshwater resources, boundaries, and the rest, and so on. As the world moved on, we find that high concentration areas or high rainfall concentration areas, especially in Europe and parts of North America, where you find also civilization came in, those navigation, the river basins and so on became navigation uses for navigation, and therefore helped in the formation of political organizations, and consequently, of course, either avoided conflicts or caused conflicts in that regard. We have one of the earliest navigational use of freshwater resources, that is in the Rhine in 805, where there was a grant of freedom of navigation. And therefore, the grant of navigation, of course, creates peace or conflict. Moving through history, is in the 18th century, we saw an increase in number of treaties. I give a number of them. In the 19th century, water resources also became, now with the Industrial Revolution, the tide changed because of the technological innovations and engineering and the use of non-navigational use of water, which changed from the non-consumptive to the consumptive uses, and of course, increased the likelihood of state conflicts. And also this increased likelihood of disagreement and question. That's why we see the raising of the rights and duties of states in the events of such conflict. The point here you note is that most water is in constant motion, and therefore the subject keeps on changing. There's the changing on the subject of international legal regimes keep on changing because of the movement of water. And to me, if Olive, I take you back after spending some years dealing with water, I find there are only two key principles which govern international waters, either to stop conflict or cause it. That is the principle of equitable utilization, and I give the cases there, Hungary versus Slovakia case, where obligations are created and rights, and also the principle of prevention of significant harm, which I think will be expounded later on. And here, of course, the question is, how do you avoid causing significant harm and therefore avoiding harming your neighbors? The point here we see is, as I had mentioned, water is in motion, is some of these obligations and principles, equitable use, principles of prevention of harm, is not absolute. And I think others will go into it without me going into a lot of that. And therefore, the question is the line between absoluteness and non-absoluteness is very thin in that regard. I also talk about the issue in the international plane, is that the moment you change the political landscapes, the maps, I will not go into certain areas, but I'm looking at when you change the political maps of countries, you find it also can end in the creation of either peace or increase in terms of conflict.
Robert, we've lost your audio. I'm not sure I'm the only one who's not hearing him.
Yeah, I think he's frozen.
Yeah, he's gone.
Should we just give him another few seconds to see if he can rejoin?
Yeah. Robert, perhaps you want to log off and try and log on again? If you can hear us.
Oh, we've lost him.
Yeah. Sorry, please just bear with us for a couple of minutes. We just want to see if our speaker can manage to rejoin us.
Angela, can you reach out to him? And all right, let's just give him another minute.
Yeah.
Sorry, everyone, and for those of you who've just joined and think you've joined a moment of silence, our speaker has just lost connection. We're going to give him a minute to see if he can connect, and if he can't, then we will proceed with another speaker.
I'm just checking my emails just to see if he has sent something. Oh yeah, sorry, he says his internet is off.
Okay, I suggest we move on to the next speaker, and hopefully Robert will come in and continue that fascinating talk. But for now, we'll everyone put a mental pin in that. Maybe we should carry on with the next speaker.
Yeah, I think we should do that. He was bringing it home. It was getting very, very interesting. Anyway, so now we have our second speaker, which is going to be Mr. Bokkang Makkota. Bokkang is an advocate of the courts of Lesotho with more than 15 years in the legal fraternity. He does work in drafting, reviewing, and advising on natural resources policies, legal frameworks, and corporate governance. He has been highly involved in legal policy and institutional reforms. He has been engaged and continues to contribute work on water resources management at both national and international level. He has acquired expertise over the years in services, including skills in diplomacy and treaty negotiations. Bokkang is currently serving the government of Lesotho under the phase 2 of the Lesotho Lowlands Water Development Project, financed by the World Bank, the EU, and the European Investment Bank. So Bokkang, without much further ado, please take over and please give us your thoughts on the issue of conflict of uses.
Bokkang, you're on mute. Oh, okay.
Yeah.
Will you press slideshow so that we can just see your slide in full? Perfect. Thank you so much.
Okay, thank you. Thank you, Clive, for the opportunity. I am Bokkang Makkota, just like you introduced myself. And my presentation will be focusing more on the legal frameworks operational in the river basin, that is Orange River Basin Commission, and specifically in the bilateral arrangement between some of the riparian states. Then I'll go further to articulate on the relationship between the river basin arrangements and the bilaterals, then getting down to the issue of conflicts that this workshop tries to address. The kind of legal framework that governs issues of transboundary water in this in the region where we are now is the revised SADC protocol on shared watercourses and the Orascom agreement of 2000, and now specific attention treaty being the Highlands Water Project Treaty, and I have singled out some of the most related clauses in the legal frameworks. These are the three legal frameworks that I referred to. As far as the revised protocol on shared watercourses is concerned, I want to mention that it is more based on the international legal frameworks, that is the UN Watercourses Convention. It fosters cooperation in the management of the SADC region's water resources management, and it also emphasizes on the reasonable and equitable utilization of shared basin watercourses, and it even encourages for the establishment of watercourse institutions, which of course must be conformed to the objective of the protocol and its principles as well. And those principles relate to the utilization, prevention of significant harm, customary international law, and the duty to cooperate, as an example. One thing that we must all take home is that the shared watercourse protocol retains obligations and rights of agreements that exist already before it came into force. Now, the river basin states being Lesotho, South Africa, Botswana, and Namibia now, based on the revised protocol and short watercourses, entered into an Orascom agreement in 2000, and the agreement was meant to promote the same equitable and sustainable development of the basin resources, and also provision of forum for consultation and cooperation, as seen in on the presentation slides. And what I must mention is that the River Basin Organization, in our case, comes as an advisory player in the River Basin Commission. It further provides forum for cooperation and sharing of information and data. These are the parties in the Orascom agreement, and Botswana, Lesotho, Namibia, and South Africa, which are fully represented by 12 commissioners with task team and the secretariat members. Now getting into the Lesotho Highlands Water Project, which is a bilateral between Lesotho and South Africa. This is a binational interbasin transfer project based on the 3 phases, and its objectives are mainly to provide or deliver water to South Africa, and hydropower generation for Lesotho. However, there are other ancillary developments that the treaty take care of. That is developments of irrigation, potable water supply, fisheries, and other activities that the parties intend to engage into. The treaty is being implemented by the Lesotho Highlands Development Authority, which is based in Lesotho. That is the one overseeing implementation and operation and maintenance of the infrastructure. There's also the Lesotho Highlands Water Commission, which oversees the whole project. Lesotho Highlands Water Commission comprises of both representatives from Lesotho and South Africa. They are based in Lesotho as well. There's also TCTA, which is a South African entity mandated to look after implementation of the project in South Africa. So now these are the kind of phases that I referred to. We have Mohale Dam and Gazi Dam being the first phases, and together with Muela Dam, which is used for hydropower generation before water leaves Lesotho into South Africa. Those three form part of phase 1A and B, which have been completed so far. And now the two parties have engaged into implementation of phase 2 of the agreement. That is construction of a dam in the project area. Now getting into the issue of water delivery to South Africa. Lesotho is mandated as per the treaty to deliver 70 cubic meters of water to South Africa when all the phases are completed. And this delivery schedule that you see here was proposed in the main, that is the Highlands Water Project Treaty of 1986. But you will realize that the delivery schedule ended in 2020, and beyond 2020, there is proposed 2208 there, which has since coming into effect of the phase 2 agreement. That delivery schedule has changed, and the revised schedule runs up to 2044. Okay, now coming into issues that may bring up some conflicts, say impairments in the implementation of the treaty or the project. Those issues are related to some delays in the implementation of other phases, which of course there have been a number of delays as we are now only entering into the implementation of phase 2. It has been delayed, I think, by a number of more than 50 years, if I'm correct. There are issues related to royalties, which could impair implementation. That is, if there is a shortfall in terms of water delivery into South Africa. That shortfall will be reflected by a reduced proportion to the royalty. So the LDA wants, if I could get a direct example, if we are supposed to deliver a certain amount of water this year, and we fail to deliver such amount of water based on a number of issues which could include drought or any other climate-related issues, the LHDA, being the entity responsible for implementation of the project in Lesotho, is then mandated by the treaty to recoup that shortfall in the next hydrological year, that is within 6 months. Then there is an issue of force majeure, that is disturbances due to extreme hydrological or other natural events, or even the extreme droughts. These are the issues that can disturb or are likely to have a potential to disturb implementation of the project, and thereby leading to what could be called conflicts. And in all this kind of situation, parties are obliged to take all necessary measures of palliation and restoration based on cooperation and consultation. The Lesotho Highlands Water Treaty has a savings clause which provides that the treaty is without prejudice to the rights under public international law of riparians of the Senku Orange River, other than the Kingdom of Lesotho and the Republic of South Africa. This is very interesting. And now looking at what I have earlier indicated as far as the SADC protocol is concerned, the SADC protocol realizes the existence of all agreements that came into force before its existence, together with obligations therein. Now coming to the basin governing legal frameworks being RASCOM agreement. The agreement in Article 1, paragraph 1.3 indicates that in the absence of agreement to the contrary, nothing in this agreement shall affect the rights and obligations of a party arising from other agreements in force prior to the day this agreement comes into force. RASCOM agreement in the same manner. It does not affect obligations and rights of parties, rights of states parties that came into existence by virtue of the agreements that were entered into before the Orange Aquifer Commission agreement was came into force. Now, this leads into what happens in case where there is a conflict between the parties as far as the water issues are concerned. I will directly relate the presentation to what exists currently or in the current past. Botswana indicated or submitted its desire to get water from the Lesotho Highlands or from Lesotho. And a reconnaissance study was undertaken, which study found that yes, Botswana could get water from Lesotho, that is both from the highlands and from the lowlands. So now, what is very interesting is, having discussed the three or the two regional and the basin agreements, they both stress on the issue of equitable utilization and other related principles. But such equitable utilization is not tied to the volumetric water allocation, which could at some point lead to some inconsistencies within the river basin as far as the volumetric water allocation is concerned. That is based on the fact that there are a number of bilateral arrangements, not only this arrangement between Lesotho and South Africa, there are other bilateral arrangements in the basin, which some are more reflective of volumetric allocation. Now, what that says in terms of equitable and reasonable utilization, bearing in mind what the protocol says, that it recognizes all obligations and rights of emanating from an agreement signed before it coming into force. Okay, there is an issue of conflict resolution under the LHWP. Conflict prevention and settlements, it is undertaken through consultations, and that is done in the spirit of cooperation. In terms of process, whenever there is a conflict arising, that is tabled before the Lesotho Highlands Water Commission. That is where both parties are represented for negotiations. And if negotiations fail, then the arbitral tribunal will be the next step, whose award is definitive and binding. Now, in the case that I have just referred to, that is where issues of water allocation in the bilateral arrangements now affect the basin management or the issues of equitable utilization in the basin setting. Now we have the issue of the agreement of RASCOM agreement, whose Article 8 is very clear in terms of how issues of disputes could be handled. It indicates that parties have to settle their disputes amicably through consultations or negotiations. Or if those two fail, they will have to approach the SADC tribunal, whose decisions are final. And you will recall that the tribunal, as we speak, is not operational. So it is still a challenge as we speak. Thank you very much.
Thank you, Bokkang, for that. That was particularly interesting because we now have a sort of a practical bird's eye view into what's actually happening in terms of an example of a transboundary water agreement and the issues that can arise in that particular context. So that's quite interesting. I'm sure there's going to be a lot of questions. I have a couple of questions for you already that I have in mind, so I can't wait to engage with you on this particular project, because as far as I know, this was probably the first successful water trade agreement between two countries. So the issues that have arisen, they are of really particular interest to me. Then now we're going to hand over to Prof. Owen Mcintyre. Prof, are you ready to present?
Thank you very much, Clive. And I'd like to thank yourself and Dina for the opportunity to address this group. I'm afraid I don't have a PowerPoint presentation. I just want to talk quite generally about the topic of conflicts of uses in international watercourses, and particularly at the issue of how human rights considerations can be incorporated into the resolution of such conflicts, and how human rights considerations increasingly shape and influence, if you like, international water law and its application and negotiated solutions. But when asked to talk about conflicts of uses, I wasn't sure where to start. Conflicts of uses in the uses of international watercourses, because conflict is central to international water law. You know, international water law is shaped by conflict. I mean, the vast majority of treaties that we use and that those of us working in this field are very familiar with, we think of them as almost foundational documents, along with many of the key seminal cases from international courts and tribunals that we rely on, actually stem from disputes. And so international water law is framed by and shaped by constant disputes. But I think what people sometimes forget is that the fabric of international water law is designed to manage disputes. Disputes are central to international water law. Conflict is central to international water law. It's a framework for managing conflict rather than avoiding conflict, if you like. So that conflict is the very lifeblood of international water law. There are multiple fault lines, you know, amongst watercourse states, but there are two key fault lines. The one we're most familiar with is that of upstream and downstream states. And when we recognize these fault lines, we understand why international water law takes the form it does. So upstream states and downstream states very often have quite different interests. The upstream state, you know, wants to use the water in an unrestricted way. The downstream state wants to receive the water in an undiminished way, an undiminished quality or quantity. So two very, very, very different types of interests that must be reconciled. But in addition to that, we have this fault line between more and less developed states, where, you know, more developed states will tend to have more industrial uses, more irrigated agriculture, more established uses, if you like. And so they tend to wish to protect established uses, where developing states or less developed states will want the opportunity and the space to develop, if you like. So again, this is another fundamental fault line. There are, of course, others depending on the conditions of a basin. And we should remember that it's very difficult to craft law in this space because no two river basins are remotely similar. Socially, economically, demographically, culturally, you know, politically, hydrologically, economically, ecologically. So very, very difficult to find one framework of law that will satisfy all states. And of course, in international law, particularly pure public international law, interstate relations, we need consent. So we have three key principles that govern this area. And I'm sorry to go back to basics, but I think it's important to explain how rights come into the framework. So the most important of these, the overarching principle, is equitable and reasonable utilization. This you know, sounds like a perfectly reasonable principle. It sounds like it, you know, it makes complete sense. So we start to dig into it. two key elements: reasonableness, the reasonableness of the use. Now, the concept of reasonableness, I think common law lawyers or lawyers from a common law tradition are quite comfortable with the idea of reasonableness. You know, we look at it in the context of the situation. What is reasonable having regard to relevant circumstances? And then the second element is that of equitable balancing. An equitable balancing, a balancing on the basis of some kind of structured fairness, a balancing of the interests of competing states. And that's at the very, very core of how international water law works. We have other rules, but they're subordinate really to this overarching framework, and they help to inform that framework. So the no harm rule, or the duty to prevent significant transboundary harm, which we're familiar with in general international law, and the general duty to cooperate, that states must engage with each other, share information with each other, you know, provide notification of new projects or planned projects, for example, notably as one of the key elements. The duty to cooperate is largely an umbrella or portmanteau term for a suite of procedural obligations, which, you know, help us to meaningfully have regard to the notion of equitable and reasonable utilization. We can't have regard to the interests of other states till we know what those interests are, until we've communicated with them and told them our plans, etc. But this balancing at the very core of equitable and reasonable utilization, it's a balancing having regard to, you know, the key instruments that we use provide an open-ended list of relevant factors. It's open-ended, and because of the unique conditions on particular basins, there may be other, you know, cultural or religious or other factors that are not listed in the key instruments, but they provide us with a list of 7 or 8 key factors, which when we drill into them, and there have been really good deep studies done on this, when we drill into those factors and the practice that developed thereunder, we find that what they really do is they inform the true extent of the dependence of each state upon the contested waters. So in other words, this is a distributive conception of equity, that the relevant factors help us to understand to what degree do each of these states rely, you know, immediately and urgently upon the shared waters that are contested. And I think once we understand that, we start to see where, you know, rights discourse can come into this framework. So you know, amongst the factors traditionally listed, we have this idea of population dependent on the watercourse. We have, of course, other factors such as, you know, ecological concerns and environmental concerns. So these are the kind of factors that are relevant. Now, if we think about a traditional legal framework, you know, a principle that allows us to make decisions in concrete situations, it's not really all that helpful to have 7 or 8 factors that we take account of, that we have regard to, arriving at you know, an equitable and reasonable determination or allocation of shared waters. That's a very, very complex you know, kind of a framework. So the problem with international water law, you know, at least at first glance, the problem is that it's normatively vague and legally indeterminate. It's nebulous in character. It doesn't help us to identify what is the concrete outcomes or outcome of any dispute. It doesn't help us to do that at all. And that is a constant refrain for scholars in this area. It's a constant criticism we hear when it's just too vague, it's too uncertain, too unclear. And that, of course, does discourage states sometimes from engaging in the process, that they're worried about what the outcomes might be. They can't begin to predict what those outcomes might be. But this was necessary from the very beginning in the design of the key instruments and principles of international water law. This was absolutely necessary, and that indeterminacy is inbuilt by design. The idea was to secure inclusivity. You know, how do we make sure that both upstream and downstream states feel that this may work, that this may be in their interest? How do we make sure that both highly developed and much less developed or least developed states that share a basin might, you know, feel that there's something in here for them? That is always going to require an element of fudge. You know what I mean? You're going to have to fudge the rules, because if it's absolutely clear how something will work, people will do the calculations, crunch the numbers and say, this doesn't work for us, and they'll walk away from the process. So, you know, it was by design, by necessity, uncertain. And so we shouldn't expect that the rules of international water law were ever designed to produce outcomes, were ever designed to identify what might be a clear outcome. They were really designed as a framework for ongoing negotiation. And here I come back to that point that conflict is central to international water law. So these frameworks like equitable and reasonable utilization, which any scholar in this field will explain to you, is procedural. It requires procedural engagement amongst states, that they share information and notify each other of what they're doing and cooperate in understanding the conditions of the basin, etc. So it provides a framework for ongoing negotiation. And in many ways, it's a starting point for negotiation on the basis of certain shared understandings, that we have shared concepts, shared definitions, shared ideas, and that we move forward from there. And in many ways, in much, when we're brutally honest about it, many of the rules of classic public international law do little more than that. And if they do that, that's quite a lot if they work in that sense. So at the core of those shared understandings is a distributive conception of equity based on the need, the dependence of states upon those waters, those shared waters. And right at the very heart of that, and if we drill back through practice, 100 years of practice in this area of interstate engagement, we find that probably the consensus exists and is further developing around a number of key values. By far the most important one is human dependence, immediate human dependence. Now it's quite easy to link that to human rights, entitlements and requirements, but also the environmental and ecological concerns, which again are easily and increasingly easily linked to human rights requirements and entitlements. So over time, what we have, despite starting from this quite uncertain and quite indeterminate body of rules and principles, over time we have incremental elaboration. And I think one of the mistakes that the classic international water lawyer does is they don't look in the right places when they say that we don't have a clear idea of what we mean by vital human needs. Well, we do if we look at human rights discourse, or we don't have a clear idea of what we mean by ecological requirements. Well, we do if we look at practice under Ramsar and under the CBD and under a range of other instruments. And there's more and more and more practice developing. And I just want to flag out a little bit of what that is. So, and all of these really find their way in. The entry point are these factors relevant to equitable and reasonable utilization. So we're not dispensing with equitable and reasonable utilization. It's a doorway, if you like. It's our entry point for these, more elaborated, what we might call sort of modern, progressive values to find their way into. Remember, international water law for much of its history was a very traditional paradigm of economic competition between states. That has changed utterly. And so we see rights much more central, environmental values much more central. So in the couple of minutes I've left, I'll talk very briefly about how we see this elaboration, first of all, in relation to ecosystems protection, and then in relation to human rights protection. So in terms of ecosystems protection, which has been a central element going back to sort of some of our key seminal instruments, the 1992 UNECE Water Convention, the 1997 United Nations Watercourses Convention, each include, in general terms, a commitment to the protection of watercourse ecosystems. And over time, we've seen how that has become elaborated. For example, the requirement for states to maintain minimum environmental flows, as confirmed in the 2013 Kishinganga arbitration between Pakistan and India. The need to maintain ecosystem services. Now, we've only really had this notion of ecosystem services, mainstreamed from 2005 in the Millennium Ecosystem Assessment. And, by 2015, we had the International Court of Justice recognizing, the denial or the being denied ecosystem services, one state being denied ecosystem services as an actionable and compensable form of damage. That's extraordinary in terms of the pace of evolution of international law. So, in the certain activities case, we have a wealth of conventional guidance and conventional procedures, and that represents this process of convergence where we're seeing, key concepts leach into, pervade into other areas of law. So, the great detail, the great wealth of highly elaborated technical practice set down under, for example, the Ramsar Convention, the Convention on Biological Diversity, other regional frameworks, feeds into international water law and must become a central part of the normative content of international water law. If we flip over then to human rights, and particularly human rights to water and sanitation, that these frameworks are now absolutely central in any concern regarding conflicts over shared international water courses. So, international water law has always had regard, and if we look into the practice, probably of all of these factors, if we were trying to identify a super factor, it was this notion of vital human needs. And in fact, people argued during the elaboration of the UN Watercourses Convention, this long process in the International Law Commission, that this wasn't even a factor. This was it had such established weight that it was a sine qua non, you know what I mean? That you allocated water for vital human needs and then you wrestle over the rest. So it was a super factor at the very least, if a factor at all. So this notion of vital human needs, if we consider Article 10.2 of the UN Watercourses Convention, which attributes priority to no other factor except this idea of vital human needs, which of course corresponds very closely with the evolving discourse on the human right to water and increasingly sanitation. That was changed very much in 2002 by the adoption of General Comment number 15 by the UN Committee on Economic, Social and Cultural Rights, which elaborated what a human right to water might mean, less a right to sanitation, but of course that has developed more since. We have instruments such as the UNECE Protocol on Water and Health. We have, I think, we have Indigenous rights, for example, ILO 169. We have various procedural instruments, ARHUS, SCAZU, we have the Principle 10 of Rio. So, in terms of the procedural elements of any human right to water and sanitation, these are well elaborated. And they tend to be instruments of global relevance, if you like. So it's very, very easy to bring those into any dispute, any conflict, any negotiation. And we're mainly talking about negotiations more than formal dispute settlement. It's very easy to bring these to the table, to make these relevant and to insert them into the process. However, where I think we've seen a game changer in recent years is the Sustainable Development Goals. And if we look at SDG 6, SDG 6 sets out, if you try to map the various goals and the various indicators under each of those goals onto international water law, they reflect international water law, but are going to utterly transform the wealth of practice in the implementation of SDG 6 is going to utterly transform the fabric of international water law by creating this wealth of practice. And if we look at goals 1 and 2 on universal access to water and universal access to sanitation, and the indicators set down thereunder and the reporting processes, et cetera, that is a game changer. That really mainstreams with a universal political commitment behind it. It mainstreams these human rights values into the fabric of, beyond the fabric of international water law, but since that's what we're talking about today, into the fabric of international water law. So we have ongoing processes of sophisticated normative elaboration, both substantive and procedural, ongoing all around us. And I've used my time, sorry. Thank you very much.
Thank you very much, Prof. Really, really interesting. And thank you for grounding us and just giving us a very conceptual understanding of some of the issues, of course, with the practical picture of what is happening out there in the field. Dina, I don't know if you've seen any questions. I don't know. I'm not sure if I've seen any questions on the chat. I've seen some comments, but I don't think I've seen any questions as yet.
I think Robert might be back with us, or he was. So maybe Robert could finish his presentation before we move on to the chat.
Yes, definitely. Robert is here, yeah. Robert, do you want to give us like about maybe, I don't know, 5 to 10 minutes tops, just to finish up your presentation? Not sure if you can hear us.
Yes, I can hear you.
Oh, yes, welcome back.
Yeah, I can hear you. Sorry, office and the internet went off, which is usually not the case, but there's nothing I could do.
No, we understand. Can we give you like 5, maybe 10 minutes tops, and then we can open the floor for everyone to ask questions?
Okay. Yeah. Okay, let me do that. Yes.
So for anyone who just joined us, Robert, or who joined us later on, Robert was actually our first speaker from UNEP, and he works on water governance. So he had sort of given us a broad overview of the work that he does in and around this area. So we just bring him back just to sort of tie up what he was presenting to us. Thank you, Robert. Please go ahead.
Yeah. Okay. Thank you. I think I had reached on the issue of the changing political landscapes, which can increase or decrease conflicts. And I had given the case of the unification of German and also the case of Yemen, northern and southern Yemen, as it used to be, where international rivers became internal instead of external, and therefore, of course, led to less conflicts. But at the same time, you see, if you look at the Nile, with the creation of Southern Sudan, it increased the number of riparians. And one can say it was also because of that could have delayed the conclusion of the Nile Cooperation Framework, because Southern Sudan is both a lower riparian and upper riparian state. And therefore the interests of that country can vary or cause a continuation of conflicts between the riparians. The other one is the political composition of shared water systems can increase vulnerabilities to conflict. Conflicts, as I had just been saying, like for example, on the Nile between the upper and lower riparians, can arise because of the varying interests of the two. But also, if you look at there are about 33 nations in the world which have got more than 95% of their territory within 95% of their territorial land considered as international basins. And therefore, if you're a sovereign state, but most of your land is an international basin, and you have to cooperate with others, which part do you remain as a sovereign state like that? I give you examples of Uganda, from where I come from. Most of the waters are international: Zambia, Niger, DRC, Bolivia, and the rest, and so on. You find that one can also increase the vulnerabilities of conflicts. How much water do you abstract within your territory, and yet it's an international basin? That is the point which I bring in, and I give some other examples of where countries have shared basins and therefore increasing vulnerabilities. There's a long list there. Sorry, I was not in a PowerPoint form. The other point which I want to bring in is because of weak governance systems in international waters, a number of conflicts can arise. These governance systems are created by us as human beings because of our weaknesses here and there. First of all, if you look, for example, since the World War, 300 treaties have been formed. Why have all those? And secondly, is that because of the human development systems, nature, we have been overusing and overstressing waters, polluting it, in exceeding the ecological capacity of those waters, and therefore, of course, causing issues of stress. If you look at, for example, 80% of all marine pollution is originating from land-based sources, and most of that 80% of marine pollution is passing through transboundary waters or river basins and the rest and so on. The impacts of climate change, I think Owen has just talked about it, and the rest and so on. We also see if people are lacking access to clean water, much as you talk about the right to water and the rest and so on. But if you have a huge percentage of that people lacking water, what type of rights are you talking about? What type of governance mechanisms are you trying to create which can reduce water crisis or water conflicts in that manner? And that essentially saying that scarcity causes stress and stress causes conflict. My panelist has talked about the Lesotho Highland Water Project. We have others like Mekong, which is shared by so many countries. But the point which I want to share is that in the 20th and 21st century, I picked 2 points which would be very useful for everyone in that we are seeing that shared interest creates broader benefits on use and control of water. And therefore, if we have many shared interests, the likelihood of conflicts become less. I give my colleague there had talked about the Lesotho Highlands and Mekong River there and so on. So you find that because you have many economic and social interests, the likelihood of you turning them into centers of conflict become less. The Lesotho Highland, Lesotho is not likely to fight to go into conflict with South Africa because of the benefit it gets in selling water to South Africa. The second point, which I see in the 20th and 21st century, is the creativity in formulating treaties, which has got multiple uses and the rest and so on, also has led to water not being a source of conflict, but a source of peace. And the old agreement of 1969 between South Africa and the present now, Namibia, which used to be called Southwest Africa, where there is the human and animal requirements, hydrological power projects, and the rest and so on, created a lot of peace in that area. And also the 1994 Treaty of Peace between Jordan and Israel also led to a lot of peace in that area of the Middle East. So you find that the trends is creativity in treaty making has reduced the number of conflicts. Having said all that, I end with the 2 points. Of course, there are many others, but I thought 2 would be useful. Is that if you have efficient and strong political, legal, and institutional mechanisms which are addressing multiple challenges within a watercourse or water basin, it therefore going into stronger governance systems and so on, the chances of crisis, conflict, stress, and so on is reduced. The second one is that strengthened international cooperation reduces interstate conflicts, forges cooperation, global security, and the maintenance of ecosystems and all that And the two cases I give is the Indus Water Commission of 1960, which has reduced those conflicts between India and Pakistan, as we know, and therefore ending up in cooperation over water, avoiding wars and political turmoil. And if you look at the Mekong River Committee, which brings together those countries in that area, it weathered down extreme political conditions and continued to have data exchange, information cooperation, and the rest, and so on, and therefore enabled those countries to thrive better in that manner.
Robert, are you still with us? I see your screen is frozen, but I think he was wrapping up. I think we're going to open the floor now to the Q&A. I will open the floor with a couple of questions that have been posted on the chat. The first question from what I see here is from Candice. So Candice says the following: in terms of reasonable and equitable utilization, agriculture and industry uses a large amount of fresh water, but the Watercourses Convention seems to place the responsibility for ensuring this reasonable and equitable use on states. Are there any developments, this is for the speakers, are there any developments in international water law that address companies and their role in water extractions contributing to freshwater capacity? Prof. Owen, Bokkang, do you guys want to try and respond to that?
Thank you, Clive, and thank you, Candice, for this question. You touch on a very central issue, and that is that public international law generally applies to states and to states alone. So states are the principal actors, and in theory, at least, the idea is that states will regulate private sector actors, if you like, other actors, under national law. Now, of course, that doesn't always work out for a whole range of reasons. A state may have limited capacity, effectively, to regulate the activity of private sector actors. It may have no great interest in doing so. You may have private sector actors that are particularly influential, particularly if it's quite a country of a low level of economic development, and this is outside investment, if you like, that's coming in and that a state seeks to attract. So there can be all kinds of difficulties and problems with that. Now, where that breaks down, we do see increasingly moves to try and expand the subjects, if you like, of international law. This is happening quite actively at the level of rights, at the level of human rights, to try and identify the human rights due diligence of private sector actors. And connected to that, we have the whole area of transnational environmental law, where we have certain kinds of standards, certain kinds of practices, which might apply to goods produced by certain actors, where we have, I suppose, an example of these non-formal or non-legal or quasi-legal standards that are emerging around the world, that are particularly relevant in jurisdictions where there is not, where there is a deficiency of effective implementation of international standards of human rights or other requirements of international law, that products produced by actors may be subject to labeling and certification schemes. So that, increasingly, if we're looking at products that have a questionable environmental footprint, I suppose a good example would be things like palm oil. If we're looking at a product that has very questionable, has major environmental impacts, palm oil, of course, is associated with the felling of forestry, rainforest and natural forest, etc., for the clearing of plantations. That increasingly, where palm oil is used, increasingly customers of the palm oil industry, right the way down to supermarkets and retailers, would require that sustainable palm oil, that some sort of certification process for the sustainability of palm oil, used in their products, etc., would be guaranteed, and that would be guaranteed through inspection, through the development of standards, etc. So this is a huge problem. We do have, water stewardship frameworks under the Water Stewardship Council. We do have an emerging, although I tend to feel that transnational environmental law is underdeveloped in the area of water use, and there's a great deal to be done in that space. But you put your finger on what is a major problem, where states do not effectively, for whatever reason, implement their commitments and the requirements under international law.
Thank you, Prof. Bokkang, do you want to respond or?
Yes, yeah, actually the issue of addressing water abstraction through national companies is entirely within the ambit of the states in a shared river basin. As far as international outer law is concerned, the only thing that we see is an attempt through the imposition or the placement of an obligation not to cause transboundary harm. And issues of dealing with such companies, they are not directly or may not be directly addressed through such arrangements, but through cooperation means. Member states under transboundary water law are expected to cooperate in sharing information, data and information, and all those in the name of water resources management, taking care of the environment and even the water use itself. So in the case of such uses, we are expecting that the states will easily comply within the ambit of international water law through the principle of no harm. Yeah, that's what I can say.
Thank you, Bokkang. That was quite interesting. There's a question from, I think it's Dina's question. The question is for both you, Bokkang, and Prof. Owen. It speaks about, it says that both of you have pointed to cooperation between the states as the primary mechanism for conflict resolution and to ensuring equitable and reasonable utilization. But in a context like the Lesotho Highland Water Project, for example, where between key parties, South Africa and Lesotho, how does this impact, since there's a significant power balance between South Africa and Lesotho, how does this impact the possibility of cooperation as a tool for addressing conflict in a way that is fair? So if I can repeat the question if it was not clear, but if it is, please go ahead.
Yeah, I think it's clear. Yes, there's a wide power imbalance in not only between the two countries, Lesotho and South Africa, I mean, in the whole basin. And one would think we wouldn't see any successes in cooperation as far as the Orange River Commission is concerned. But this boils down to the issue of the related interests by each state, as Prof has said. The dependence of states on the river course and even the drivers of cooperation, which will always lead to the state needing more in terms of cooperation. For instance, Africa needs water from Lesotho, and at the same time, Lesotho is interested in generating hydropower and even getting some royalties from the same arrangement. So such kind of issues are those that lead to or drive the issue of cooperation even to the highest level of the basin arrangements. We can now make an example of Botswana, which contribute very little into the system. Namibia is downstream, and at some points they don't receive what is expected, but still those countries are cooperating in terms of the legal frameworks, because their interest is in the river system and the use of it. Thanks.
Thanks, Bokkang. Prof, do you want to respond?
If I may jump in there very briefly. It's a great question, Dina. And I think, inequality of arms has long been a problem in international relations, and so of course, it is a major problem where we have a technically sophisticated framework, if you like, for, identifying, quantifying articulating and balancing interests. Certain states come along with all of the technical capacity to do so, and certain states come along with very, very little capacity to do so. And for many, many years, that has long been a focus in terms of when one has the opportunity to advise development partners on programs of action and stuff. And you're saying you really need to help certain states that are pivotal, central states on key basins. You really need to help those states to sort of to play the game, to play their hand, if you like. But I mean, what we do see, and if we look at Southern Africa, for many, many years, there was a major imbalance with South Africa. South Africa was the hegemon, if you like, in Southern Africa, and had that weight of technical ability, and also had that weight of that legacy weight, where people within the DWAF in Southern Africa, these were the guys who knew the background, the technical background to all the existing agreements, you know what I mean, and why agreements were framed the way they were, what was meant by particular concepts and frameworks, etc. That has changed, where the capacity has improved in all of the neighboring states and all of the other co-basin states. But it's incumbent upon a hegemon in these situations to assist at a technical level, to assist less capacitated states if you want meaningful cooperation. If you think, for example, around efforts towards integrated catchment management in Lesotho, like who's going to benefit from integrated catchment management? It's South Africa that will benefit from integrated catchment management, probably more than the people of Lesotho in many ways. And so, there was a real responsibility on states to take, a state that you share a basin with will always be your neighbor, always. And so there's a great deal of interdependence there. And, there's for an enlightened government, there's a great incentive to improve the technical capacity of that state. One other thing I would say is that, and I've written about this on different occasions, that what we see in international water law is an increase in what I would refer to as proceduralization. That much of that interaction is less substantive and more procedural. And proceduralization of legal frameworks helps to level that inequality of irons, if you like, that it makes it quite clear that one state must notify the other state in a way that that state can use, if you know what I mean, and may have to assist if you're talking about environmental impact assessments of a major new project, may have to assist the notified state in securing, independent technical capacity or independent technical advice to be able to be in a position to respond meaningfully to notification. And so proceduralization, I think, helps, rather than putting a big, difficult to digest, substantive obligation, if you like, on all states. Proceduralization makes what states must do more clear, and it also makes it very, very clear when there might be an obligation on one state to assist the other technically or in terms of resources. Thank you.
Thanks, Prof. A follow-up question from Fabiola. He says, can an international water treaty be successful when it lacks the key rules of contemporary transboundary water, such as equitable and reasonable utilization and the no harm principle? Here he speaks to the Amazon Cooperation Treaty, which even lacks a dispute resolution mechanism. And to that, maybe I might even add the Lesotho Highland Water Project Agreement itself, which in my view doesn't seem to cater to equitable and reasonable utilization. So your typical transboundary water principles seem to be missing there. Do you want to respond, Prof? And then we can go to Bokkang.
Yes, thank you, Clive. I would comment on, I would make a note on your comment first about the Lesotho Highlands Water Project and that the agreement doesn't refer to equitable and reasonable utilization. I think it's important to distinguish between a river basin agreement or a watercourse agreement and a project agreement. You know what I mean? That the project agreement is much more specific, is much more focused on the project and the sharing of benefits from that project. So I wouldn't be too surprised or disappointed that it doesn't refer to these larger, broader concepts, such as equitable and reasonable utilization. But if we take instruments that don't include a reference to equitable and reasonable utilization, it's unfortunate that they don't, and one would expect that they ought to, because though indeterminate, what something like equitable and reasonable utilization does is it infers, very strongly implies, a level of procedural engagement. But procedural engagement in and of itself the end that one pursues. It's procedural engagement, having regard to a particular strategic direction. So, equitable and reasonable utilization provides a strategic direction. I sometimes, explain that sometimes to an audience that it's a bit like a state of grace for a Christian. You never get there, but you sort of, the idea is that you spend your time trying to reach a state of grace. You'll never have a perfect, equitable and reasonable resolution or settlement or position, because population will change, demographics will change, dependence will change, economic patterns of use will change. So it's this kind of vaguely out of reach, a strategic direction. So you would hope that, states sharing a major basin would identify and then seek to pursue some type of strategic direction. So it's a little bit disappointing when it's not included in an instrument, but it is inferred because of it's a universally accepted principle of international water law. It would have no question, it would have customary status and ergo omnes status. But I think what we might find is when you look at an instrument like the Amazon Cooperation Treaty, look at the preambular paragraphs, look at the objectives, and you will be able to infer a particular flavor of equitable and reasonable utilization having regard to the instrument itself. Thank you.
Thank you, Prof. I don't see any other questions unless I've missed anything. Dina, do you see anything I might have missed out on in terms of questions? We've got about maybe 3-4 minutes left.
Maybe Bokkang wants to respond to the last question now, or if he has anything to add.
Yeah, one of the reasons why I tried to provide some background from the SADC protocol down to the basin agreement and the bilateral arrangements. I wanted to draw that distinction that Prof has just referred to, that irrespective of the basin arrangements, there are a number of bilateral agreements in the basin, which are in the form of projects and a number of institutions. So in this case of the Lesotho Highlands Water Project, yes, looking at the preamble of the treaty, you'll find that there's some reference to the issue of benefit sharing and utilization, which to me was a bit surprising, Prof, because the treaty was signed a long time ago before we even of this kind of principles. But there's such, and I think, as far as I'm concerned, the principle of reasonable and equitable utilization evolves with time and needs and interests of states as developments go on. So it is upon the two states to indicate or to find themselves whether at the right time, as we speak now, whether the treaty is still responsive to the issue of equitable and reasonable utilization as it was designed from 1986. Yeah, thank you.
Thank you very much, Bokkang. Thank you for actually capturing the idea that the whole idea of equitable and reasonable utilization is sort of an evolving principle, which is what Prof was talking about now, that it's not something that is set in time, and it seems like obviously like it's a living principle. And as population dynamics change, what would be equitable and reasonable in that particular space would change. It's something that I've grappled with over the last few years, but listening to you, Advocate Makkota and Prof Owen, it's become much clearer to me at least, and I hope to our audience. This has been such a fascinating discussion. We actually didn't have enough time to actually engage a little bit more because I've got other questions connected to the very interesting question that Dina had asked about, power symmetry and how that impacts the provisions in this type of agreements. But thank you so much to Robert from UNEP, to Advocate Makkota from the Lesotho Highland Water Project, which is obviously a practical scenario of a transboundary water agreement, and to Prof Owen, who is obviously one of probably the leading authority in the area on transboundary water law and the relevant governance principles in that regard. Thank you to everyone who attended. We appreciate it on behalf of the Global Network on Human Rights and the Environment. Thank you for joining us, and thank you for all your inputs and for this discussion. We hope to interact with you more. Please note that there's the session, the summer school is ongoing for the rest of the week, so please register for the other sessions and please join us. We can't wait to engage with you further. So this is not the only platform we can engage with you, but on behalf of the Global Network on Human Rights and the Environment, thank you to everyone who attended, and also a special thanks to our 3 panelists who availed themselves and were really generous with their time to interact with us. I know all of you are quite busy with really heavy matters relating to the state, so we want to let you go. Dina, do you want to say anything in closing?
Just to echo Clive's thanks, I think what was really kind of fantastic about this was that we got this very sort of applied, in-depth perspective on the Lesotho Highlands project. We got quite a kind of historical sort of view of and view from Robert, but we also got this kind of very clear connection to human rights and the ways in which human rights can inform and help our understanding of kind of not just conflict, but cooperation around transboundary waters. So thank you to all three of you. And thank you very much to Clive, our moderator exceptionnaire today. And as Clive said, we have a number of really interesting panels coming up, many of which look at the governance of water in different contexts. We have a panel, for example, on Thursday on governance systems, comparing governance systems in Brazil and China. And one of the things that panel is going to look at particularly is business and human rights and water governance. So come back to the rest of our sessions, have a look at the program on our website. Many thanks to our partners, and big thank you to our presenters again. See you at the next one.
Cheers, guys. Thank you.